You were just involved in a self-defense shooting. The police are on their way. What do you say? Can you say anything at all? I'm going to break it all down for you. Stay tuned. Hey guys, Attorney Marc Victor here with the Attorneys for Freedom Law Firm. Now look, we monitor all of our YouTube videos and the comments that are put up there because we want to be responsive to what you guys want to know. We got a really good comment recently about more information in terms of what do I say to the police? Okay, I understand this, but let me step back from that for a moment and just say it's close to impossible to give a general piece of advice that applies to every conceivable factual situation. Some people, and some of them lawyers, have said after a shooting, always say, I was in fear for my life. Okay, now you might think that that's a pretty good general piece of advice. And in a lot of cases, it would be. But in some cases, it might not be. What cases might it not be? What if the reason you shot somebody was not because you were in fear for your life, but you were protecting a third party, someone else, right? You might actually be justified in shooting the bad guy in the back. And a shot in the back would be difficult to defend with the legal theory, I was in fear for my life. So don't lock yourself into that theory. Additionally, there are other legal justifications for why you might be allowed to shoot and kill another human being. In many states, there are statutes that allow deadly physical force to be used if it's immediately necessary to prevent another person from committing one of the enumerated crimes that are on a list, usually pretty serious crimes. But what if that justification actually fits the facts better? And I shot because I was in fear for my life is really inconsistent with that defense. Okay, why is this a problem? Imagine you get to trial and your lawyer notices up a defense that says the reason you shot was to stop a person from committing one of the other crimes. Don't you think that prosecutor is going to parade out your statement at the scene where you said, I shot because I was in fear for my life? And then the prosecutor's going to have a field day with that in front of the jury. Ladies and gentlemen, first the defendant at the scene said the reason he shot was he was in fear for his life. But now today, you heard a completely different justification. Isn't that convenient? How do you avoid all this? By keeping your mouth shut. Even that, I know, sometimes still raises questions and isn't perfect advice because there might be times when you actually need to say or do something. So let me try to give you a little more guidance here. First off, and we're talking about after a shoot here, right? Because there are many other times where you might find yourself talking to the police, right? What if you get pulled over for speeding? Okay, different set of rules over there than after a shoot. Sometimes it could be a shoot and maybe nothing happened. It was an accidental discharge. Probably don't call the police on yourself. Seen that really go very badly. But the police could be called, and that might be a different circumstance than a shoot, and now somebody is laying in a pile of blood on your carpet in your living room. Those are different circumstances that might require slightly different responses. So I like to break them down into two different boxes. Box number one, human life is in danger. And box number two, human life is not in danger. First, box number one. If human life is in danger, you really should act to get some help for this person. Even if you're dealing with a bad guy. I mean, after all, it's still human life, and generally speaking, we want to do our best to save lives. So what that means is you gotta get some help. Okay, sub-question, should you call 911 or should somebody else call 911? Well, our preference is always going to be somebody else should call 911. What is it we want to communicate to 911? Okay, the minimal amount of information. Why do we want to communicate that? Because we don't want to be locked into a legal theory. We don't even want to be locked into the fact that you were the shooter. Maybe there's nobody who can say who the shooter was. You can imagine different facts here. I've had cases, by the way, where it was clear that a crime was committed, but it could have been committed by many different people. And if everybody keeps their mouth shut, sometimes the state can't prove who the perpetrator was. Okay, These are hypothetical, sort of esoteric situations that are hanging in the air because we're not tethered to any set of facts. But if you got to get 911 there, first choice, get somebody else to make that call. We want as little information as possible. But there are some things that we can sketch out that probably have to be communicated. Like, for example, human life is in danger. Send help. We need medical attention. Okay, that's one piece of information. Another piece of information, here's the address. Here's where you need to send the help to. That's fine. I think that's probably enough. There might be some situations where you might need to add a little bit more. Maybe somebody has a certain particular kind of health problem that you know about that you need to communicate. Okay, you might want to communicate that as well. First choice, have the other person communicate that. Okay, second choice, if nobody else is around, well then you might have to call 911. But same rules apply, right? Somebody is injured, human life is in danger, here's the address, please send help, goodbye. Now, why do I say goodbye? Because you know that 911 operator, while they're sending help, is going to also be conducting an interview. Okay, what happened, sir? Was there a shooting? Who was the shooter? Where's the gun? Something like that. On that point, you might want to add a little bit of information. The scene is now secure. There's no threat to the police. I will be out on the street with my hands up just so there's no confusion. Something like that. No problem with anything like that because it doesn't get to really what the facts of the case are. I mean, look, if it's clear there was a shooting, they're going to show up and somebody's got a bullet hole in them. It's okay to say there has been a shooting. Okay, that makes sense. Don't say I shot somebody. Say there has been a shooting. Okay, so you got to communicate some of that information to save human life. But if human life is not in danger, well then keep your big mouth shut. Now you might want to call your attorney. If you talk to an attorney and you're talking to a competent attorney, that attorney is going to tell you keep your mouth shut. Now, some people absolutely can't resist talking to the police. I know this because as a young lawyer, I used to tell people keep your mouth shut. And then they used to get charged with crimes and come into my office, and then they talk to the police. And I used to say to them, why did you talk to the police? Don't you remember me maybe speaking to you at the gun show or giving some speech somewhere where I said, keep your big mouth shut? And they say, yeah, but I just felt like I should say something. All right, for these people, I've actually drafted up a statement that I put on the back of my business card, and I've had it there for many years. Here's what I wrote, and I'm reading this to you because there's nothing objectionable, in my view, in this statement. So let me read it to you. This is what's on the back of my business card. It says, I refuse to consent to any search whatsoever. As such, I do not consent to a search of my premises, my person, my immediate location, or any vehicle or effects. I hereby exercise my rights as enumerated by the 4th, 5th, 6th, 9th, and 14th Amendments to the United States Constitution and Article 2 of the Arizona Constitution. I demand to have my attorney present prior to and throughout any questioning at all. Additionally, I request to call my attorney right now for a private legal consultation. Okay, so a few things here to talk about. First off, don't say you exercise your right pursuant to Article 2 of the Arizona Constitution if you're in a different state. Okay, substitute your state's constitution. If you're in South Carolina, say, I exercise my rights pursuant to the South Carolina Constitution. Now, why? There might be some rights under this local state constitution that are actually broader, provide more protection than under the federal Constitution. So that's fine. You might have also noticed that I threw in the 9th Amendment, and you're probably scratching your head and saying, what the heck is the 9th Amendment? Okay, I could cut another video talking about the 9th Amendment. You don't hear much about that. It's in there. Okay, maybe just a tidbit about it. I like the 9th Amendment. Why do I like the 9th Amendment? Because when the Bill of Rights was adopted and attached to our Constitution, a lot of the Founding Fathers didn't want that. And the reason they didn't want that is they said things like, why do we have to enshrine a right to keep and bear arms when the Constitution gives no authority to Congress to deprive us of the right to keep and bear arms in the first place. The whole idea of the Constitution is we've given these specific, limited, delegated powers to Congress to do things. Said another way, if we haven't listed the power here to do it, they got no right to do it. So we don't want to say you can't take away the right to keep and bear arms. And the argument there is if we say that, well then those will be the only things that are protected, right? The right to free speech and the right to keep and bear arms and the right to not be subject to unreasonable searches and seizures and on and on. Well, to avoid this problem, they put the 9th Amendment there to specifically say, hey, just because we've enumerated a whole bunch of rights in the Bill of Rights doesn't mean those are the only rights. There are a whole bunch of other unenumerated rights out there. We don't mean to not include those as well. That was the whole point of the 9th Amendment. Okay, suffice to say, they haven't found any rights in the 9th Amendment. But it could be a fertile ground for more expanded individual liberties someday. But I put it in there because it gives me something to argue to the judge, and we like to be creative at our law firm. Now, you might have also noticed that this is a pretty broad statement. It also deals with searches and seizures. Makes it very clear under the 4th Amendment that you are not consenting to any searches of your person. It doesn't mean that you're guilty because you refuse to consent to a search. Okay, the 4th Amendment, like our other rights, the Second Amendment, the First Amendment, this was a very hard-fought right. You got a right to be free from unreasonable searches and seizures. Don't just give it away by consenting to a search. If they get a warrant, that's a different issue. That's part of your rights. They got to take it to a judge who's got to say, here's what they're looking for. Here are the things that they're describing with particularity that they're looking for. They don't get a general warrant just to search stuff. And the judge has got to find probable cause exists. There's some reason for the search. Don't just give up your right to be free from unreasonable searches and seizures. Okay, a couple other things in here that are interesting. Of course, you're exercising your right to have an attorney present for questioning. Okay, that's important. I want to pause on that just for a second. There's a difference between either remaining silent or saying, I got nothing to say, or saying, I want my attorney present throughout any questioning. Okay, the difference essentially is in the first two cases where you didn't mention the magic word attorney, lawyer also works as well, they get to continue to ask you questions. Hey, we got another question for you, Mr. Jones. What about this? What about that? What about the next thing? Oh, I got nothing to say. I got nothing to say. I got nothing to say. If you say, however, I want my lawyer present, now they got to stop asking you questions. It's not just that. They can't do things that are reasonably calculated to get you to answer questions either. There have been some cases where officers have had sort of side discussions in earshot of the defendant, calculated to get the defendant to say things. Okay, if the defendant or the person under investigation says, I want my attorney present, that's it. All questioning must stop. And if it doesn't, even if you answer the question, there's a pretty good argument that there's been a violation of your Fifth Amendment right, and maybe that statement can be excluded, at least at trial. So that's a good reason to read this statement and maybe say a little bit more. And then finally, to say, I want to talk to my lawyer right now for private legal consultation. I like that a lot because technically under the Sixth Amendment, you don't have a right to counsel until you're actually formally charged. However, there are some aspects of the state constitutions and some arguments under due process, Fifth Amendment or 14th Amendment, that if you asked to talk to your attorney pretty quickly and they denied you that right, and they didn't have a good reason to deny you that right, that can bring a motion to suppress information or to dismiss the case if the violation is serious enough. Here in Arizona, the state constitution allows you a right to speak to your attorney as soon as is reasonably practicable. That doesn't mean you get the police officer to stop in the middle of the arrest and let you call your lawyer. Okay, no state is going to be that tough in terms of allowing you access to your attorney. But if you're just doing nothing and they could otherwise allow you to call your lawyer and they just deprive you of calling your lawyer, it might give rise to a good argument. So I got no issue at all if you say early and often, hey, I want to call my lawyer. Oh yeah, we'll get to you later. You say again, hey, I want to call my lawyer. I still haven't had a chance to call my lawyer. No problem. Keep a little mental note of how many times you have asked for your lawyer. It'd be excellent if you can get that on the body camera, assuming the police officer is rolling, so that later on your lawyer can say, hey, they deprived my client of his or her right to have a conversation with a lawyer, and judge, that's just not right. Sometimes you can get a judge to bite on an issue like that. Also can be an important point to negotiate a case with a prosecutor. And keep in mind, just because you're on the phone talking to your lawyer, that does not prevent or stop the police from making an arrest of you. That takes precedence. That's the way the law is. I'm not saying I agree with it, but officers are afforded a lot of discretion at the scene. So if you're on the phone with your lawyer and you hear the police officer say, put the phone down, you're under arrest, you're going to have to comply with that officer. And if the lawyer on the phone hears that, very likely the lawyer is going to say, okay, you got to put the phone down. I would also add to that, let me speak to the police officer. Sometimes a police officer, they don't have to do this, but sometimes they'll actually talk to us. I've talked to many police officers at the scene on the phone. Sometimes I can calm them down or get more information or maybe deliver some relevant portions of the story that they should know about. Remember, just because you're not speaking at the scene doesn't mean your lawyer can't bring up whatever facts are in your favor very quickly to either the arresting officer or the prosecutor who's going to make a decision. So remember, you got to comply with that police officer's commands, even if you are on the phone talking with your lawyer. That's the very long-winded way of saying there is no general advice, right? The thrust of what I'm saying is assert your rights. Don't give information about what happened, right? That's what the police are going to want to get from you right there at the scene. And usually, remember, after a shoot, this is the worst possible time to be making a statement. If you actually had a shoot, you're going to be freaked out at that moment in time. You're not going to be cool, calm, and collected. Very likely, you're going to have all kinds of adrenaline flowing through your body and other various hormones flowing through your body. You're going to be freaked out. You're wondering what just happened, what's going to happen. Really bad time to be making a detailed statement about what just occurred, or said another way, locking your future criminal defense lawyer into a specific legal theory. That's what we want to avoid. There is no problem whatsoever with being very kind to the officer and civilized, saying, officer, I understand you want to know what happened. Maybe I'd even like to tell you, I got a whole bunch of things to say, but my lawyer, you can even say, if you want, my friend, criminal defense lawyer Marc Victor with Attorneys for Freedom law firm, specifically advised me to not make any statement until I talk to him. Can I call him right now? You could even go so far as to say, if Marc says it's okay to talk to you, I'm happy to talk to you. Do you know that little conversation there about you requesting your attorney is not going to be admissible at your trial? That's right. The jury is not going to hear, the government is not going to get to present that you were asked to tell your story at the scene and instead you said, I want my lawyer. They don't get to bring that in. You got a right to remain silent, you got a right to ask for your lawyer, and the jury doesn't even get to infer something negative from the fact that you asked for a lawyer. Therefore, they don't even get to hear about it. So it's always good to invoke your right to a lawyer early and often. All right, so I hope that clarifies things a little bit. When in doubt, just shut up. Okay, that's the safest thing to do. If you want to give your name and where you live, give them your license or something like that, no problem with any of that. But the question, what happened? Are you the shooter? Tell me what occurred. All of that in a very kind, nice, respectful way, just decline. Sorry, officer, I've been advised to talk to my lawyer first. Most officers will understand that. I've represented many police officers in my time. That's the advice that they give to each other. That's the advice they give to their kids as well. Most police officers will understand and respect the fact that you invoke your hard-fought constitutional right to remain silent. Okay, as always, like and subscribe to this video if you want to receive other videos just like it. If I didn't fully answer your question, leave a comment down below. Whether you agree or disagree, no problem, right? We're Americans. It's okay to disagree. If you bring it civilized, you'll get a response from us. If you want to find out more about the Attorneys for Freedom law firm, that's pretty easy. That's my law firm. We're actually a pro-freedom law firm, and we've been in business 27 years. Just go to attorneysforfreedom.com. If you want to find out more information about the Attorneys on Retainer program, which is this really cool program that our law firm has cooked up for people who are concerned about being charged with a crime and then claiming self-defense and not being able to afford an aggressive, professional, experienced team of criminal defense attorneys who will rush in and defend you in any of the 50 states. If you're interested in that, check out attorneysonretainer.us. Thanks for watching this video. I hope it was informative. Feel free to check out any of the other many videos we have on all kinds of things criminal defense related. Peace.